All right, let's go on the record in State v. Kohberger, CR 0124316665. The defendant has been excused from today's proceedings. It is not present. The defense is represented by Ms. Massoff, Ms. Taylor, and Ms. Barlow. The state is represented by Mr. Thompson. This is a time set for a hearing on the state's supplemental request for restitution. The state can argue first.
Thank you, Your Honor. The attached documentation, it doesn't appear that there's a question about the amounts. I think the question that has been raised is whether the propriety of any additional restitution being ordered at this point. Yesterday afternoon, we did receive a supplemental filing from the defense, and I want to respond to that just for the record before I address the merits of the restitution requests themselves. As we indicated in our response to the defense objection to the additional restitution request, at the time that we entered into the plea agreement, Ms. Jennings and I were under the impression that crime victims' compensation could be available to cover reimbursement of travel expenses. And I have to clarify that now. It is true that before trial, the families approached our office asking if there were any resources we were available to pay in advance for travel expenses or expenses related to them attending trial itself. And we looked into that, our staff looked into that, and advised them no. It was my understanding, and I'm mistaken, I realized I was mistaken at this point, but it was my understanding back in early July, late June, when we were talking about the plea agreement, that crime victims compensation could be available to reimburse expenses like that. I now know that's not correct, and it was certainly my mistake. I will own it as far as our state of mind going into the plea agreement. So that being said,
go ahead.
I'm sorry.
Go ahead. I'll let you finish the point on the plea agreement, and then I have a question for you about that.
And I was just finishing that point, Your Honor, so this would be a good time.
Okay. So it's pretty well settled that plea agreements are interpreted as contracts, which they are. I think it's pretty well settled contract law that a unilateral mistake does not relieve one of its contractual obligations and restrictions. So how can I how can I order this restitution if the express terms of the plea agreement, though mistaken understanding by the state, don't allow such extra crime victims compensation fund reimbursement?
And Your Honor, I recognize that, and that's what I was just getting ready to address. In response to the defense's objection, the state has modified or adjusted our position on the restitution. We are, pursuant to the plea agreement, seeking restitution for the funeral-related expenses, which are the urns that are described in Exhibit 2 to our response. We are not affirmatively advocating for the travel expenses and lodging expenses of the family because we do not believe that we can legally advocate for those. At the same time, the families provided those to us, and we want to provide them to the court and counsel just so everybody was aware that they are there, but we are not arguing affirmatively for that because of the wording of the plea agreement itself. So what the state is actually requesting today is just additional restitution for the funeral-related expenses, which are the urns for the families.
Okay, thank you. And you can address the other issues as well.
I'm sorry, Your Honor, which other issues?
Well, the issues, if you'd like, raised in opposition to your motion, including the lack of ability to pay by a defendant and et cetera.
Yes, thank you, Your Honor. I apologize. The defendant has raised the issue of his alleged inability to pay, and we recognize that he's going to be incarcerated until he dies. But that in and of itself doesn't mean that over the course of the balance of his life, he might become, he might receive assets. And in fact, we attached a breakdown of the types of monies that he has received during his incarceration. We also noted the statute that allows the treasurer to intercept prospective monies that might be received based on any attempted publication of the story of the defendant. And those, if received, would be something that a restitution order could be enforced against. We also note that the language of the statute and the case law interpreting the restitution statute, which is 1953-04, if I believe off the top of my head, talks about current inability to pay is not necessarily a block to the order of restitution. It's just merely a factor for the court to consider. And it is our position, given the relative youth of the defendant, the fact that he has been receiving significant monies during his incarceration already, and that there is the possibility of future monies, whether by virtue of the statute with the treasurer impounding proceeds from a story related to this, or perhaps from an inheritance from his family or others. We can't see into the future. We don't have a perfect crystal ball. The state's position is having this additional restitution in place, which is really fairly minimal, would be appropriate. And have them available that if the defendant comes into assets, that the families would be able to try to satisfy the restitution orders from them.
Thank you. And then who's arguing for defense?
I will be, Your Honor.
All right.
Thank you. Given that the state has clarified its position that it's only seeking reimbursement for the earns, it's my understanding that that amount is $1,420 for one family, $1,587.79, and then another $167.79, which would be a total, I believe, if my math is right, of $3,075.58. My understanding of reading the Victims Compensation Code 1953-04 is that the court must still do an analysis on Mr. Kohberger's ability to pay. And as the state has addressed, we are arguing that he does not have an ability to pay. While there have been lump sums provided to you regarding some funds that he received prior to his plea agreement, what the court does not have is a breakdown of how those funds came into the inmate system for his expenses and the fact that they were primarily family. Certainly his situation pre-plea and sentencing was drastically different than it is right now in terms of money that is available to him. And there's nothing in the record to provide the court with anything other than what is really speculation based on the past, as opposed to something that the court might be able to rely upon about foreseeability. There's no way that Mr. Kohberger is ever going to profit from any sort of movie or book because Idaho Code 1953-01 specifically precludes that.
Well, it precludes, it allows that monies are swept from his account for those income to pay certain things. If those certain things, if there's no debt for those certain things, then does the money not go then to the defendant?
That is not my reading of the code. Perhaps I'm reading that statute more broadly than the court is. I understood it to be that the purpose is that someone can't then profit off of their crime pursuant to that statute. I guess I need to read it with that broad implication.
Even allowing your reading of it, what's to prevent, for example, a family member from agreeing to, provide information, be a part of, et cetera, a story, movie, book, whatever, TV series about the murders, about Mr. Kohberger, and that certainly wouldn't be, monies they receive wouldn't be subject to the statute, and then they certainly would be free to send Mr. Kohberger money to his account. What harm is it to order the restitution, which would then sort of jump in line in terms of priority of payments over some of the other ordered payments, such that if Mr. Kohberger does receive money into his accounts from any source, that he's then, that those monies are then put to that use. Certainly, we're not worried about Mr. Kohberger's credit rating with having debts at this point. I'm not sure what the concern would be to, given the uniqueness of this case and the potential for family members, et cetera, to earn money from it, and potentially we've seen members of the public send money to Mr. Kohberger, is my understanding, to his books. What's the downside to ensuring that the victims are as whole as possible from this by ordering the restitution, which again would jump in line from some of the other court-ordered fines, et cetera? And if the money's there, it's there. If it's not, it's not.
Judge, I don't see that Idaho Code or Idaho law asks the court to make an analysis on the downside, but whether or not there is foreseeability of payment. And all of the things that you just listed are pure speculation. There is no book or movie that's in the works by any of his family, and to say that those things are going to happen is absolutely speculative, and there's nothing to substantiate those sorts of assertions happening in the future. So
well, there's a history in the 3 years he was incarcerated of him receiving 5 figures put on his books. Doesn't that give the court some history to suggest that such contributions from whatever source may continue into the future?
As I stated earlier, Judge, that was at a different time in the case. That was at a time when, he had not entered a plea. He was not deemed convicted of the crime. The money, a lot of that money was coming from his family to be able to have communications with their son and brother. And to speculate that those types of dollars are going to be able to happen for the next many decades is exactly that. It's pure speculation, not based on something that is foreseeable or based in something that's in fact before this court.
Well, it just seems to me that one of the, really, obviously, even application of statute requires the court to look at what might happen into the future. And I guess, it seems to me one of the best indicators of the future is the past. And in the past, his family has, you're saying the family was the source of much of these funds, has provided him funds in order for him to communicate, et cetera. That necessity will still exist going forward. I'm not aware of his family having disowned him at this point and not wanting any contact with him. And even if they are, that doesn't mean that won't change. And you call it speculation. It seems to me that it is good evidence of what may occur in the future in light of what has occurred in the past.
Well, Judge, there is a judgment against him in the amount of $28,000, and certainly 20% of every dollar that goes into his inmate account is going to go towards paying that $28,000. Another factor that the court actually can look at under 1953-04 subsection 7 is other factors, and those factors that other factors that the court deems appropriate, and that can be collateral resources that the families obtained over $200,000, which definitely reimburse the cost of the earns in terms of economic costs.
I also want to turn to the plea agreement, Because isn't a reasonable interpretation of the plea agreement that the defendant will not contest the state's seeking of restitution that is outlined in the plea agreement? Otherwise, why would it need to be in the plea agreement? It seems to me it's the plea agreement, a reasonable interpretation is the defendant is agreeing to pay restitution for those items that are identified in the plea agreement, which includes victims' compensation, which includes in this case funeral expenses. So you took advantage of the plea agreement to get the benefit of the bargain regarding the state's dropping of the death penalty. Why should you not be held to the plea agreement to pay the victims the costs of interning their children?
Judge, I believe that our pleading was clear, that we understood that urns fell underneath a funeral cost, but that once we have a hearing on this matter, that doesn't eliminate the court's duty under 1953-04 to do the ability to pay analysis. And that's why.
Well, are you in violation of the plea agreement by arguing that your client shouldn't have to pay those?
We are not in violation of the plea agreement. If there was any violation of the plea agreement that took place, it's the state seeking this when the other expenses, when it was clear under statute and under the Idaho Victims Compensation rules that those were not reimbursable expenses.
But they've effectively withdrawn those requests and are seeking what's outlined in the plea agreement. What's the point of the plea agreement on restitution if the defense is able to argue against the restitution called for in the plea agreement itself?
Judge, again, in our pleading, we objected to what the state has withdrawn as of this moment at this hearing today.
Right.
We acknowledge that the urns were funeral expenses.
Right.
But once we're in this situation of having a hearing, then this other section about whether or not he has an ability to pay is triggered. We stipulated to $28,000 in restitution within 60 days.
Right.
He met the terms of the plea agreement.
But it also says the state may seek restitution regarding funeral expenses, and they're simply identifying additional funeral expenses.
I don't know what more you want me to say about the urns other than
what's the point of the plea agreement if you're not going to be bound by it?
I agreed that it was $3,075.58.
But you say you shouldn't have to pay it.
What I said was that the court needs to do the analysis under Idaho code about his ability to pay.
Why hasn't the defendant waived his right to rely on that ability to pay by agreeing to those expenses as part of the plea agreement?
I don't know how the court can enter this order today without engaging in the analysis under Idaho code because it's required. That's the way I review the case law and the code, that once there's a hearing about restitution, then the court has to engage in the analysis on the ability to pay.
So the agreement to pay is illusory.
No, he agreed to $28,000. We've agreed that the urns fall underneath.
Does he have the ability to pay that?
No, he does not have the ability.
So why did you agree to it?
Because it was a specific, we were provided with those receipts within 60 days. We were not provided with the receipt for the urns within 60 days.
So is your objection then a timeliness objection?
We did raise a timeliness objection in our pleading. I have thought about that and whether or not I think that it is a really valid argument to say that that's completely jurisdictional. I didn't to mean that the court can't take this under the review at this point in time. I didn't read the judgment language in such a strict fashion that I felt like we could say 61 days means the court's not going to not going to consider it at all. So it is past your 60-day deadline, but I don't know that that is completely jurisdictional in the way that you drafted your judgment.
Anything else?
No.
Thank you. Mr. Thompson, any rebuttal?
No, Your Honor, thank you.
All right, thank you. I'll take the matter under advisement, issue an opinion in due course.